Can you hear me? How many of you have been hit by a dawn raid? Any dawn raid veterans here? I mean, once you've had it happen, you know how to deal with a dawn raid, don't you? Well, just for your information, the Competition Commission is in Durban today. They haven't yet published their press release about who they're raiding, so I can't tell you. But I did get 2 calls this morning saying, help! When do you get into serious trouble with the Competition Commission? There are 4 what they call per se offences in terms of the Act. You know them: price fixing, market division, tender collusion, minimum resale price maintenance. There are a couple of dominance ones that are quite tricky as well, but for the most part, it's the 3 biggies that we're going to deal with today, agreements between competitors leading to one of those 3 things. The Competition Commission has taken its lead from Europe and from the States, and on the 14th of July 2017, they published these draft guidelines. They're largely drawn mainly from European guidelines. The European guidelines are much more detailed, much better written, and actually very, very informative. So if you really want to know what the South African guidelines are likely to be interpreted as meaning, read the European ones as well. The European ones actually express themselves as being European guidelines relating to agreements or between undertakings. The language is a little bit different, but the idea is the same. There are really 2 golden rules with competitors. Golden rule number 1, any interaction between competitors is likely to provoke suspicion on the part of the Competition Commission. That's the first thing. Golden rule number 2, if you have to interact with a competitor, you need to think to yourself, I need to limit the information to that which is strictly necessary, and I need to think about the information exchanged and work out what I can exchange, thinking about this business as if it's mine, and knowing I want to share with that competitor as little as possible. So don't just work as if you're employed by a large corporate and it's not really relevant to you. It becomes relevant to you because if you're a senior manager or a director, you can go to jail for helping participate in price fixing, tender collusion, or market division. Okay, so 14 July 2017 are the draft guidelines. They were published. We've got until September to do the amendments to those guidelines or propose amendments to them. They don't bind the Commission, but then neither do the ones that are applicable in Europe or the ones that apply in the States. They always say, all these guidelines, the Commission is like SARS, they never bind themselves to anything. They just say to you, we'll give you an idea of what we're going to do, but we'll consider this on a case-by-case basis, and we'll make up our minds as we go along. So to some extent, the law on this is actually drawn on competitor information exchange, will be drawn from cases as we go along. They do indicate the Commission's likely approach. And as you will see as we go through these guidelines, that likely approach is very, very restrictive. There is very little you can legitimately discuss with your competitor. The other thing that I think is very telling about these guidelines is that they make a big fuss about trade associations or industry associations. And this is something I've been telling my clients for ages. If you are going to be a member of an industry or trade association, you need to ask yourself, why? Because any industry or trade association, in my view, has got a big bullseye painted on it. It's saying, I'm a target. You want a group of competitors chatting to each other? You come chat to me. Easy, quick way to get a group of competitors together and to find out what they're talking to each other about. Go and look at the trade associations. So if you are a member of a trade association, you need to be really, really careful about that membership, and you need to be sure that there are good, legitimate reasons for that membership, because membership of a trade association is a high-risk activity. That is quite clear from these guidelines. The guidelines say quite expressly that they've drawn the guidelines up partly because they've been approached by trade associations on a number of occasions and been asked, what can our members talk to each other about, and what can we as an association, what information can we gather and disseminate amongst our members? You know what this says. This is Section 4. This is the tricky one for cartel activities. You get two kinds of Section 4 information. Section 4 basically governs relationships between competitors. 4.1 deals with anti-competitive arrangements between competitors which are substantially anti-competitive. That's a rule of reason offense. Information exchange not relating to prices, costs, rebates, trading terms, quantities would probably fall into that category. So strategic information exchange outside your price fixing market division arena goes into that area. Also, information exchange which is not considered to be part of a cartel type arrangement would probably be dealt with under that, depending on the type of information exchange. If you've got a group of competitors who say, no, we're not a cartel. We just chat to each other about our pricing every month so we can make sure that we're benchmarking and pricing really efficiently. Tough for you, I'm afraid. You are in the price fixing box. And price fixing is B, directly or indirectly fixing a purchase or selling price. Remember, purchase price makes us a bit different from Europe and the States. You can have buying cartels in Europe and the States. In Europe, it's limited depending on collective market share of the members of that group. Here, you're not allowed to. Do you remember the Parmalat Dairies thing? Where the dairy guys all got together and they said to their farmers, this is the price we will pay for your milk. That was a buying cartel. It's illegal. You're not allowed to do it. Okay? Selling cartels, where you set your selling price, are far more common, but buying cartels are forbidden in South Africa as well. Trading conditions. Trading conditions in the very old Potensi citrus case has been defined as relating to quality-quantity nexus. So if you short the market, you're likely to drive prices up. If a group of competitors having substantial market share all get together and agree to short the market, what's going to happen to the prices? Straight through the roof. So, controlling production, controlling capacity, making decisions about prices, costs, rebates, payment terms, publishing your terms and conditions of business, including your price-sensitive information on the internet and saying, this is my price list. Well, you're just looking for trouble if you do that. Dividing markets, you divide markets by allocating between the competitors, customers, geographic areas, suppliers, all types of goods or services, and then tender collusion. Well, everybody knows about the construction debacle. It goes on and on and on, more and more bid rigging. And those of you will have seen at the yesterday, Commission has now decided to refer to the tribunal 649 counts of tender collusion and price fixing against Stuttervids for government contracts. Every contract that they've found, they've said is a separate price fixing offence. The European authorities might have a different approach to that, but our authorities want to hit them for 10% of their turnover on each one. Don't think that you need a legally binding agreement to form a cartel arrangement. For those of you planning to set up cartels, you can do it with a nod and a wink. You honestly just need an understanding between you. You can even form a cartel, a thing called a tacit cartel, by simply signaling to each other in the market in different ways, and we'll go through that in a bit more detail just now. The guidelines copy that definition of an agreement. Don't think that you can go to a meeting of competitors, they share information about prices, and you sit there and you think, I'm going to cheat, I'm not going to do this, I'm not going to be found guilty of cartel activity, because silence is consent. This follows the European and American authorities, which Arida and Hovenkamp are two of the best and most world-renowned writers on competition law. They're Americans. And Arida uses a very, very good example to illustrate this point. He said, imagine if you, as a competitor in a market, invited your fellow competitors round for dinner. And we have a lovely dinner together. And at the end of the dinner, the person who invited you starts chatting about pricing. You've now moved from a nice social arrangement into a business arrangement. If you do not expressly distance yourself from that conduct in South Africa, you'll be found guilty of cartel activity. The Europeans have got quite clear guidelines. They draw a distinction between someone who leads a cartel and someone who's playing a follow my leader kind of role. We don't have that degree of finesse in terms of our definitions yet, but we are led by other jurisdictions, so that may become relevant. But the point is that we've got two cases. The bottom case is a competition appeal court case. The line I thought there was very telling was they say their silence can never equal non-participation. The cumulative effect of conduct, whether active or passive, when assessed in a particular context, is equally compelling. You can go to jail for being quiet just as easily as for actively participating in a cartel. You have to have an agreement between competitors. Now, what's a competitor? The example I always use when we do training about competition law is, do you think that the corner cafe competes with the Pick and Pays? Arguably, they don't. They're not at the same level of the market. The Competition Commission, though, has a very, very broad approach to the definition of competitor. And that's illustrated by these guidelines. The Competition Commission's view is that a competitor is anyone trading in the same market. Then you get sub-markets within markets. And remember, you can conduct yourself at one level of a market in a way which impacts on another level of the market. So there's leveraging that also applies. Anyone who's actually competing in the market and anyone who has the potential to compete. Now, that's not a speculative inquiry. You have to say to yourself, can somebody enter this market quickly enough and on a scale sufficient to genuinely compete? The only case we've got about this is the Telkom merger decision, but that gives you a bit of an idea. Just to highlight, per se, that's a go to jail, do not pass go, immediately off to jail card. If your conduct fits the definition of the offense, you are per se guilty, whether your conduct has actually had an anti-competitive consequence or not. If your conduct is not one of the offenses that is regarded as being so heinous in competition terms that you don't get punished for it once you fit the definition, it's called a rule of reason offense. And there, the authorities have to prove that the conduct has a sufficiently anti-competitive consequence to justify you being found guilty. Communication between competitors can be beneficial to competition. You get JVs when companies can't do something on their own. They don't have enough capital to make the necessary investment. They don't have the know-how, so they combine their technological capabilities and develop something that's new and innovative and something that brings benefit to the market. They learn how to position products better. They give consumers more choice, better prices, more efficiencies. There are benefits to be obtained. But there's a very big but here. The problem is that almost all the cases that have dealt with cartels that have started out, often they start out from something which is legitimate. The Unilever case, which took place in Europe a few years ago, involved Unilever, Henkel, and Procter & Gamble. And what happened in that case is they got together to agree the size of packaging for washing powder. Because if you look at a box of washing powder on the shelf and there's a box this big and a box this big, it doesn't matter whether the actual mass of the washing powder in those boxes is the same. Most consumers will just pick the big one. And that's not good for the environment. We use too many trees to make boxes this big. So the guys got together with a perfectly legitimate purpose, reducing the size of the washing powder packaging. But it evolved into market division, and let's agree a few prices, and you have Germany, and I'll have France, and you have Italy, and that's forbidden. That's forbidden. You're not allowed to do that in the EU or here. Okay? That's market division and price fixing. Bang, fine. Our guidelines here, the draft ones, say that competitor communication may be permissible about, now get really excited because this list is so long, accounting methods, stock control or bookkeeping practices, just don't show them the books, huh? New technology and research results. Now, even the research results in the EU and the States, they've got specific guidelines dealing with R&D arrangements, which we're not going to deal with now. We haven't evolved to that level yet. The point is, if you're going to do any kind of joint venture, your first port of call has got to be the joint venture practice note, which the Commission has put out. The second one is you have to again say to yourself, like you would in a trade association, is this joint venture essential? Is there a good objective commercial reason why I can't do the task that will be set for this joint venture on my own? What is that? Do I not have enough money? Do I not have the capability? What is that reason? And then if you are going to do a joint venture with a competitor, there are a couple of rules about that we'll deal with just now. So why does the Commission get so hot and bothered about communication between competitors? Their trouble is that as soon as they talk about what they call the cartel dilemma. The cartel dilemma has two aspects to it. The one is, how can competitors, if everyone's so suspicious and they see that if one competitor talks to another, they immediately assume that there's a cartel happening, how can competitors communicate with each other initially to set up the cartel? That's cartel problem number one. Cartel problem number two is, once we've organized our cartel, how do we monitor everybody in the cartel to make sure they're not cheating? And those two collectively are described as the cartel dilemma. Now, the Commission, the guidelines, you'll see this theme coming through the guidelines. The Commission does not like competitors getting together in a legitimate platform because that gives them the opportunity to go from discussing washing powder boxes to discussing prices. You start with a legitimate platform, you end up talking price fixing. So, we have to be really careful about that. The EU guidelines are of the view, they say it's perfectly fine for firms to adapt intelligently to existing or anticipated conduct in the market. But you can't share strategic data with a view to eliminating uncertainty and increasing transparency. The minute you start doing that, either directly or indirectly, you're going to be in trouble. Information exchange is sharing information which has a particular economic value. Wonderful definition, don't you think? It actually doesn't say a hell of a lot. Anyway, examples that they give are information about prices, output, capacity, strategy, costs. Now, this I found very interesting. The Commission's view, you remember I said to you, Section 4, you've got the two offences. The one is the rule of reason offence, which is generally anti-competitive conduct between competitors or agreements between competitors. And the second rule, the second prohibition is price fixing, market division, or tender collusion, right? Now, the Commission is quite interesting. They draw the distinction between those two, not on the basis of the type of information exchanged. They draw the distinction on the basis that efficiency defenses are available in the first anti-competitive offence and they're not available in the second, which is an obvious distinction and correct. But for me, it's more the type of information that makes a difference there. The second category is they say A applies where there's no cartel and B applies where there is a cartel or where there's an attempt to establish a cartel. So they look at these, the way they examine information exchange, they do this with almost any competitive problem, is they'll say, what is the anti-competitive conduct? What is the effect on the market of this behavior? And these are the kinds of things they look at when they're assessing information exchange to see whether it is anti-competitive or not. The first thing is obviously what type of information are we exchanging? What are we talking about? Are we talking about prices? Are we talking about sales volumes? Are we talking about anticipated future investment? Because you would not believe how many people tell the world about their grand plans to build this plant or establish this new fancy mill or whatever it is. So the type of information that's exchanged, the market structure, are you dealing here with a highly concentrated market, just a few players, where it's easier to talk to each other because you know there aren't 100 of you, there are only 2 or 3 of you? How disaggregated is the information that's being exchanged? Is it national information that is a year old? Is it by customer, by particular type of product? Because if you're talking high degree of disaggregation, information that even if it's old information, even if it's 3 months old, it may still be very valuable to competitors. Remember our cartel dilemma? Recent information that is on disclosed on a disaggregated basis enables cartel players to monitor whether Joe Bloggs was cheating 3 months ago. And then you can actually pull him in line. That's the whole point of cartels. Exchange frequency. How often do we chat to each other about this information? How often do we exchange it? And the age of information. The EU also has a look at the mechanism that is used for exchanging information. And there's some fascinating ones. We'll go through one of the cases just now, EU decision, where you had both Japanese and European players in the market. They were using encrypted emails, encrypted cell phones, private emails on a Gmail type account, that kind of thing, to exchange information. It was very cleverly done. Ran for quite a long time. So, competitive harm is irrelevant when you're dealing with price fixing. All the Commission is interested in is, are you dealing with competitors who have agreed directly or indirectly to fix prices, divide markets, or to collude on tenders? If so, you're guilty, even if the agreement hasn't yet been implemented. Even if you just attended one meeting and you went away thinking, I'm going to cheat, but you didn't put up your hand and say, that's it, we're not doing this, I'm not participating in this, it's illegal. If you do that, you're guilty. So the Commission also identifies these questions, and this is largely drawn from the European rules. Are you dealing with past, present, or future conduct? And what for me was fascinating about these guidelines is that they focus a lot on future conduct. And they also prohibit comments about competitors, because they say that information that you as a firm put into the market about your attitude to what a competitor is doing, or what you will do if a competitor does something, amounts to signaling. You're communicating with your competitors about what they may or may not do, and that impacts on the market. What's the market structure like? Are you dealing with a concentrated market? Are the market shares more or less even? Have you got a few players in the market, or are there lots and lots of players? Is it a very dynamic market? Does it change regularly? Markets that are highly innovative are much more difficult to cartelize. Trade associations. I cannot stress my concern about trade associations enough. I've been saying for years, and it's proved positive in this and in various investigations that are being carried on by the Commission, trade associations are highly risky. The Commission also wants to know if you are exchanging information, is that information, and you say that the exchange is necessary to achieve some kind of efficiency benefit. The Commission wants to know whether the information has to be exchanged in order to achieve that efficiency benefit. Is it indispensable to that efficiency benefit? Because if it isn't, the Commission's going to take the view that you're exchanging that information so that your competitor gets a better perspective on the market. It's part of a cartel arrangement. The Commission goes very quickly to you're participating in a cartel. They don't need much encouragement to immediately start thinking that. Okay, so we talked about type of information, how it is shared, the mechanism for sharing the information, market conditions, past information. If you're giving historical sales information, that can impact, it's a way of monitoring a cartel, and it enables the cartel members to see how you're doing and governs future behavior. If you are exchanging, the key question here in relation to aggregation is, can a particular firm or customer or area be identified from the information which is exchanged? If it can, that's trouble. That's really trouble. Okay, frequent exchanges are obviously more dangerous than ones which are, for example, annually in arrear. Even a single exchange can be evidence of collusion. A lot of the agreements that have been concluded, you had one meeting, and thereafter the guys either dealt with by way of signaling or emails and telephone conversations. The older the information exchange, the better. And if you've got price negotiation intervals, say you've got 3 monthly price negotiation intervals and you're exchanging information annually, you will have 5 or 4 price changes before the next information exchange event occurs, which means the information is quite dated in relation to pricing, and you won't necessarily be able to get a good steer on your competitors' pricing. That is much safer than every quarter being a quarter behind in terms of the information exchanged. So information about current prices and trading terms will immediately be considered to be indication of price fixing, participating in a cartel. Why are you telling your competitors what your current prices are? Exchanging information about the terms of your recent transactions can also facilitate coordination, will also trigger suspicion. In fact, not much won't. Using a subscription service. So if you are subscribing to some kind of marketing research body and you get reports, and from the reports you are able to establish your competitors' market shares, that too can create a problem. And asking competitors for prices is a serious no-no. I mean, frankly, I hope none of you are dim enough to do that. General rule about future conduct is that information about a firm's future conduct or anticipated or expected competitor future conduct is considered to be anti-competitive, exchanging that kind of information. Because again, you're signaling to each other. You're having a conversation in a public forum. You can't talk to each other directly, so you're sending a message through the media, through customers, through suppliers, whatever you do. Don't talk about, the simple rule is, don't talk about anything which you, if this were your business, would not disclose to your competitors if you wanted to compete on the merits. Sharing information within a group, trade association again, the wording from the guidelines is it's highly suspect. Up to you. You want to take that risk? Communication about future conduct when it's reasonable to expect competitors to receive that information may be collusive. So when you've got a situation, which I know a lot of the shipping guys have, where the customers will ring you up and say, listen, so-and-so is giving me this price on this box to Dubai or wherever it is, what price are you going to give me? If you have that situation, there's a high degree of transparency in the market, and you are relying on that customer conduit or supplier conduit to give information to your competitor. Now you're into a hub and spoke cartel. I'll show you a picture of that just now. The Commission will evaluate the market structure. The kinds of things they look at are what we've been talking about. Are you dealing with a homogeneous product or service here? I mean, really, yes, you get ships of different sizes, but honestly, sticking a box on a ship and taking it from A to B is not really, it's not like it's cell phones or computers which evolve really quickly. It's a service which is relatively homogeneous. It's like buying grain or buying wheat. Those kinds of things are homogeneous. The product is standard, relatively easy, much easier to deal with. They're not vast distinctions between products. High degree of concentration, level of transparency in the market. Now, the weird thing about this is sometimes a highly transparent market, I mean, in a perfect competitive world, every competitor knows what every other competitor's price is, and he prices accordingly. But the problem is that the Commission adopts the view that transparency, too much transparency, can lead to is evidence of competitors chatting to each other within a market. So you've got to be a bit careful about that. A low degree of transparency, what you've also got to be careful of, the European guidelines are very helpful here, because they talk about a change in transparency. So if you've got a market where nobody knows what anybody else is doing, and suddenly everybody seems to know what everybody else is doing, that's indicative that something material has changed in that market structure, and the Commission will prick its ears up. Symmetry and stability of market shares. Have the market shares changed? Have they changed a lot? Over what period did they change? Have there been any interruptions in the changes in market shares? Or have they remained remarkably stable? And if so, why? Barriers to entry. The general rule is where you've got a concentrated market with very little product differentiation, that facilitates collusion because it's easier to collude in that kind of market. Right, if you share only amongst competitors, that kind of sharing is regarded as suspect by the Commission. They say that quite bluntly. Are you thinking trade associations again? I hope you are. Sharing with a wider audience, expecting competitors to become aware of the information may also become anti-competitive. That's what we've just spoken about, where you disclose to a customer prices, knowing that that customer is going to pass it on to your competitor. This is the warning to the trade associations. Aggregated information that is to be disseminated amongst industry players must be accessible to all the industry players simultaneously, whether or not they form part of a particular industry association. What they're talking about here is where members of a trade association, an elite little club, get a head start on relevant anti-competitive information, or information that can be used for anti-competitive purposes. So we've talked about this, type of information aggregation, age, confidentiality, frequency of exchange. Efficiency benefits, is it indispensable to achieve that particular efficiency benefit? If you're talking cartel conduct and information exchange in that setup, this is irrelevant. Doesn't matter. You can have the most pro-competitive reason in the world for exchanging your prices with your competitor. The commission doesn't care. You will be guilty of cartel conduct. And it's not just prices, remember, it's elements of prices, so rebates, discounts, trading terms, your payment terms, all that sort of thing. The information exchange has to be limited to that which creates the lowest risk to competition. If you're now slipping extra information in there, you're sending messages to your competitor, or that's what the commission will think anyway. And it must be limited, same kind of thing, to what is relevant and necessary to achieve the efficiency gains. The commission is usually suspicious anyway. It doesn't take much to make them more suspicious, but they will be particularly suspicious of any interaction between competitors which is direct or indirect. Platforms. Platforms are ways and places that the competitors can legitimately talk to each other and exchange information. So if you've got a joint venture, that joint venture becomes a platform because you have to have board meetings, you have to have shareholder meetings. Those are perfectly legitimate places to talk to your competitors. Conferences, trade association meetings, again, all perfectly legitimate platforms where competitors can exchange information. The trouble is when those competitors start exchanging information that they shouldn't be talking about with each other. We know what that is. So the commission also looks at how the information is exchanged. And sometimes the how is an indicator of the fact that the competitors knew that they were up to no good. I mean, the one cartel that the commission has relied, the one cartel case the commission relied on, the one I spoke about earlier with the encrypted emails on a public email server, all that sort of thing, that is an indicator that the parties knew that what they were doing was wrong. Tacit collusive agreements. These are very troublesome. And unsurprisingly, we can't get much guidance from the Commission as to what will constitute a tacit collusive agreement and what won't. There's not a lot in the way of case law here. The one case we have got is from the European Union, where prices were announced every quarter, a few weeks before the beginning of the next quarter. And the Commission in the EU found that to be indicator of a price fixing cartel. The reason for that is they said there was quite a long advance warning given to each competitor of the new prices. The prices were also all announced more or less at the same time. In addition to that, the prices were fixed for a quarter. The competitors weren't agreeing longer term agreements for better pricing terms with customers. That was all indicative of the fact that there was a cartel running on prices. Indirect cartels, I'm sorry, you probably won't be able to see the writing at the back, but basically it says competitor to competitor through a supplier, customer, or trade association. And that's the way information can be moved from one to the other. How are we doing for time? Okay. Information provided to regulators, that's fine. The catch is, if your trade association or you competitors get together, you exchange the information, collate it, and then give it to the regulator. Now you're exchanging information. And the fact that the regulator says he wants it is tough. Doesn't help you. This is competitively risky. An industry association is not independent. So don't think that you get out of jail by getting your industry association to collect all the information. You've got to get an independent person to do that for you. Disaggregated information must be kept confidential. Only aggregated information may be disclosed to the competitors. And you only share what's relevant and necessary. There's quite a lot of repetition in the guidelines, but it's quite important to read the whole thing. Trade associations can legitimately engage with regulators on policy issues, but information exchange in a trade association has to be treated with the same degree of care as information exchanged directly between competitors. That is the message that these guidelines are sending. Pay attention, guys, because trade associations are definitely on the Commission's hit list. Government supplier initiatives, we'll just whip through this quickly. Aggregated nationally, more than 5 suppliers, shared quarterly in arrear, no sharing of certain information. Guess what that is? Definitely no absolute bar to customer information and marketing strategies. Now, you've got to be careful because this also intenders sometimes. You know, particularly with being forced to comply with various bits of requirements for various bits of legislation, local content requirements, the preferential procurement regulations, those sorts of things. You've got to be careful when you're tendering that you're not contravening these requirements. Public announcements and signalling, be careful about that. We've spoken about that. Reciprocity is not required. Information exchange, it's a bit of a misnomer, but it can be a one-way street. Can be signaling. We've spoken about all of this. JVs. First of all, be aware that if you form a JV, you may have to report a merger. Secondly, in operating your JV, be very, very careful because the Commission may regard a JV between competitors as a disguised cartel. So you'll need to show, for example, that you needed to form the JV and what your legitimate objective commercial reasons for doing that were. It is regarded as an information exchange platform, and you mustn't share more than is strictly necessary in the JV. Now, this is a very important one. The JV must not eliminate competition between the partners. Now, if you think about that for a minute, the partners have got their business at this level. They've got shareholdings in the JV, which is down here. In that environment, competition is obviously eliminated because they've partnered for the purposes of the JV business. At this level, they must still be competing. And if they aren't, the Commission will regard that as an indicator that you're running a cartel. Cross-directorships and shareholdings, very, very problematic. You see this often in the merger legislation, merger cases that are coming through. Small shareholdings by one competitor in another enables that competitor to place a director on the board, see disaggregated financial information, sales information, costs information, and other strategic information. It's obvious if you think about it. You've got to be a bit careful about this one. In fact, you've got to be extremely careful about it. Quotes for customers, sometimes where customers request quotes. Well, Stutterford's is a perfect example of that, isn't it? What happened in Stutterford's is they would give a quote to government and they would get one of their competitors to quote to government and say to the competitor, listen, you can't quote more than X. This is my job. It's called cover pricing. Benchmarking. Hooray, the Commission has finally accepted that benchmarking can be useful. Quite interesting, because at the moment, I'm looking at another case. The Namibian Competition Commission has just published a case saying that the Medical Aid Society there, which sets benchmark prices for medical services, can do that legitimately and it's not price fixing. Well, in 2005, the Board of Healthcare Funders in South Africa, which does exactly the same thing, was found guilty of price fixing for doing exactly the same thing. So we've got a very different approach to benchmarking and publishing tariffs and recommended tariffs. That's very dangerous. Here, all the case law so far indicates that benchmark tariffs are likely to be regarded as price fixing or heading down the road to price fixing. Right, you know about this. It's a go to jail free card. The criminalization provisions came in May 2016. It applies to directors and senior managers. It applies if you knew about the price fixing, so you engaged in or knowingly acquiesced in the price fixing, market division, or tender collusion. And knowingly acquiescing is basically turning a blind eye. You ought to have known. So just to remind you, the Act came in 1998. Some of the cartels that they're dealing with date back to the 1970s. The Rockler Concrete Piping Cartel, 1970s. They don't fine you for that period, but they take account of the fact that you had a cartel running. It was a long-standing cartel. So why would your behavior be likely to change in 1998? More difficult to challenge that. Okay, May 2016 is when the criminalization provisions came in. These are the EU cases, and they are extremely interesting. Here, we had the guys who make glass that's used for TVs and computer screens. And there's some famous names there. Samsung actually is involved in 2 of the cases that the Competition Commission relied on in developing the guidelines. This cartel ran just for a year or 2. It met to fix prices. It was indirect coordination by disclosing at meetings past, present, and future information about pricing and market positions. And they knowingly, the important thing is, and you see this line a lot in EU cases, they knowingly substituted practical cooperation for the risks of competition. The LCD case, again, the screens on computers, it was the liquid crystal that goes in between those screens. Samsung again, they applied for leniency. This ran for about 5 years. Effectively, they divided the market into Japan and Europe. Well, it was the Taiwanese and Korean companies, and they had the East, and the European companies stayed in Europe. The principle here is if you're participating in a market, you must develop your business policy independently of your competitors. You mustn't make your decisions knowing, obviously your decisions are informed by what you find out about their behavior, but it's how you go about doing that that's important as well. Right. This was about bananas. Chiquita and Pacific basically sold bananas. And the issue here was the claim that there were contacts between competitors which were allegedly legitimate. The legitimate platform principle, remember, does not in any way rule out the possibility that collusive conduct took place. So there's a distinction between independently gleaning information, discussing future pricing, and discussing price-setting factors or the evolution of prices before deciding your prices. So when you get together and effectively agree the prices, that's a problem. Switchgear, this one ran for a long time, 1988 to 2004. And these guys basically divided the market into the Japanese market and the European market. And within Europe, they had another division within the European market. These were the guys who had the secretary companies, and it was all run very efficiently. They had rules that they'd all signed. They did market studies to check no one was cheating. They checked with customers periodically that no one was cheating. The tractor guys had quite a good argument that they weren't actually running a cartel, and their argument was that the information they were exchanging was information about the number of tractors that were registered, new sales. So it's kind of like our vehicle registration. NAMSA publishes information about new vehicles that are licensed. These guys formed a trade association. That trade association took all the registration information and then put it together and disseminated back to the members of the trade association by type of tractor, brand of tractor, all that sort of thing. So again, the European Union found this to be anti-competitive. Wood pulp is really important. Cited almost every time you deal with price signaling. The wood pulp, there were groups of wood pulp producers in Europe who basically signaled to each other prices by way of public announcements to the specialist press or customers. The Americans have a law which allows them to form cartels outside America. And the American export cartel effectively traded in Europe and then got hit for cartel activities in Europe. Okay, these guys were supplying Toyota with wiring harnesses, and they cheated by phoning and exchanging information. And you'd be relieved to know that that's that. Any questions? Okay, so anyone who participates in price fixing, market division, or tender collusion can apply to the Competition Commission for leniency. You get leniency if the Competition Commission decides that you've cooperated sufficiently with them and disclosed to them all the information that they need at your cost about the cartel activity. And you only get leniency if you disclose to them information they don't already have as a result of an investigation they're running. And you only get leniency if you're the first person to blow the whistle on your cartel. If someone got in before you, well, tough. You lost out. Sorry. You disclosed all the information, blew the whistle on the cartel, but someone got in first, okay? So you then get fined. There are draft administrative guidelines on fining administrative penalties, but they're only in draft form at this stage. The European Union basically gives you a discount. The bigger the discount, the quicker you settle. So if you've got 4 people in a cartel, it goes leniency 0, 75, 50, 25. Okay. So, be careful, though, with leniency, because since the criminalization provisions have come in, that becomes now a very interesting question. Do you, as a director or shareholder of a company, what decision do you make? Do I report this cartel? The Commission definitely goes much more gently on people who are leniency applicants, but remember that the Commission isn't the person who makes the decision about whether you're going to get prosecuted. That is the National Prosecuting Authority. The Commission just gives you a certificate saying you're deserving of leniency, if they think you're deserving of leniency. Good question, thanks, Nat. Anyone else? Yep. Safety issues, health issues, if you're lobbying with government about change in legislation, those sorts of things are normally okay. You've just got to be really careful. You've got to take a step back and say, is this competitively sensitive information? Yeah.
I think you might have asked a similar question to mine, Peter. Constitutionally, we are entitled, or employees are entitled to establish a trade union, employers entitled to establish an association. I see there quite an interesting difference there, especially with your comments about trade associations. And then when employers are in a trade association or in a bargaining forum, they are bargaining together for what they will pay their employees. Why we allow that and not some of the things that you describe, which I understand fully are not allowed? Why is there this contradiction? First, in the Constitution, allowing us to establish trade associations, and then secondly, when we negotiate for everybody. Seems contradictory to me.
Okay. The Constitution permits employees to unionize, but it's employees to unionize.
Oh yeah, well obviously employers don't unionize.
No, obviously.
But it does allow us to establish a trade association.
Well, you can establish an employers' association for the purposes of negotiating wages collectively. And that is what the Constitution has allowed to protect the interests of employees, because employees have always been regarded historically as being in a weaker bargaining position vis-a-vis their employers. The problem with competitors getting together is that most competitors who get together for legitimate reasons, some of them stay on the straight and narrow. But there are many, many, many cases all around the world of competitors who got together, formed an association for valid and legitimate reasons, and strayed over the line, couldn't resist that temptation to chat about other things that they know they ought not to be talking about. And here, part of our problem has been education, becoming aware of what we aren't allowed to talk about, because we've had a culture of there seems to be a pervasive culture that it's okay to chat to your competitors about prices. People don't think it's wrong. Well, nowadays that's much more risky activity. Yep.
With certain supermarket chains, you get a certain credit on your next purchase if you could have purchased that product at a lower price elsewhere at that time. So obviously there's a way for one chain to monitor the prices of another.
Yeah, it's called secret shopping. No, it's a recognized thing. It's called secret shopping. And the Commission has made it quite clear that you can send a secret shopper to go and shop. And all the supermarkets know who the secret shoppers are. But you cannot ring up the supermarket and avoid the effort of going to collect your market intelligence yourself. If you want to get market intelligence, you have to make the effort to get it. Yeah. Lebo has just suggested that we park all further questions, and if you want to chat to me during the tea break, that we do that. Sorry about that, everybody.